We're live.
All right. Oh, I need my cap. All right. Welcome, everyone. We will stand for the Pledge of Allegiance, please. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I want to say good morning, because we usually have our commission meetings in the morning, not morning. Good afternoon. If you're here, please make sure you sign in. There is a sign-in sheet on top of the bookshelf. If you come up to the podium, please state and spell your name for the record. There's a couple people here. I just want to tell everybody, we're going to be talking. I will ask for public comment. We'll start the meeting with public comment for items not on the agenda. Then we'll go ahead and roll into the agenda item. And if no motion is made, I'll definitely still get public comment from everybody, so don't worry, I will ask for it. If motions are made, we'll ask again after the motions are made for more public comment. Let's see. Is there any public comment on subjects not on the agenda that the commission has jurisdiction over? Is there any public comment? Okay. I have one announcement, and that is that the Skidway Campground is going to be closed. It is closed for road work. They're estimating August 11th through September 12th, but they do think it's going to be done quicker than that, we all hope. So they're moving forward with that. If there's any questions, that's through the Forest Service. Okay. We're going here today to talk about discussion of decision, establishing a process for DEQ, Department of Environmental Quality, letters of approval for accessory dwelling units within subdivisions. And I will go ahead and let our planning director, Nicole Brown, read that off.
Good afternoon. You're right, that is difficult to remember to say afternoon. My name is Nicole Brown. I'm the Broadwater County Community Development Director and Planner. Thank you, Commissioner Rickmeyer. And thank you, Commissioners Swenson and Randolph and Rickmeyer, for putting this on the agenda so rapidly so we could have this discussion today. Essentially, my request for this meeting was in relation to ADUs, which stands for accessory dwelling unit, within subdivisions, and when DEQ, the Department of Environmental Quality, requests planning department approval, how to proceed forward with that. For a slight bit of context, when Megan, our sanitarian, who is here in attendance today, has a request for approval to DEQ, I receive a letter from her seeking planning comments and approval. I base my comments and subsequently approval solely on the subdivision application itself. So if this ADU request is for a lot within a subdivision, I go to the subdivision application, I pull the application to determine how that subdivision was submitted. If the application was for one single family residence per lot, I cannot give my approval to Megan's request to DEQ, simply because that application states if it's for one single family residence per lot. That's how I reviewed the application. That's how the planning board reviewed the application. That's how the public was able to participate and comment based on the contents of that application, and subsequently how the commissioners give their preliminary and final plat is all based on that application. So it's a very important piece of the subdivision itself. That application is the very most important piece of a subdivision. So I cannot give my approval essentially to DEQ or to the applicant seeking the approval from DEQ seeking the request, because the application, if it states one single family residence per lot, I can't go against that. So seeking information from you commissioners, our county attorney, Mr. Bratcher, Megan Bullock, our sanitarian, if there are any other options moving forward that you would like me to look at, any other, I don't want to say a way around, is there any other information that I can review to assist me in giving that approval, or does anyone have any ideas, I suppose?
I'm going to back up really quick, if that's all right.
Absolutely.
Because this discussion kind of sparked with a new law that just came out, new legislation, that consequently we found out after more investigation that is irrelevant for Broadwater County because we don't have zoning. So we know that ADUs are going to be a topic. The only way, well, let me go back up. It seems like the only way, the first thing you have to look at if you want an ADU is what your covenants say, right? Because the covenants supersede anything we say, any decisions we make. That's correct?
Madam Chair, you're asking me, correct? You'd like me
Yes.
to respond? Okay. Yes, the covenants would always supersede. And it's also very important to know that the county does not amend or approve covenants. That's solely the landowner, their request, or the subdivision resident's request. So we are not enforcing covenants either. So if covenants were to state all homes in a subdivision must be painted pink, we're not going to go out and enforce that and ensure that all houses are painted pink. However, if someone comes in and requests to build a blue house, we can't agree to that. Maybe that's a poor example. We don't have building codes, but you understand where I'm going with this. Mm-hmm. We as a county cannot be a party to the dereliction of the covenants or deviating from the covenants, but we are not going to enforce covenants.
Okay, so in the process, I want an ADU. My covenants say I need to get, I can't have an ADU, basically. So the first step in any of this is handling your covenants in your subdivision, first part of the process. Say that gets handled, that issue's out of the way, then it would come to us in order to get DEQ approval, correct? Like we have to say yes or no. The commission has to say yes or no in order for DEQ to say yes or no to the client or whoever is asking to do the ADU, right?
No, not entirely. The commission does not get asked to say yes or no. I do as the planner.
Okay.
The request comes to the planner. It doesn't come to the commission. Okay. And also in the covenants, back to the statement, the county's not enforcing covenants. If the request comes from DEQ for my comments and approval, I don't go to the covenants to ensure that. I go to the application only.
Okay.
Simply because we're not enforcing covenants, and so I don't, while we hold the covenants, and I say we, I'm using that collectively as the county, it's specifically the clerk and recorder's office holds the covenants. They could say anything, and I'm not going to review them to determine if it's a deviation from the covenants or not, because that, I believe, would give the perception of a legal opinion.
Okay.
Because they are a legally binding document, but only between the subdivision residents. So I wouldn't even look at the covenants.
Okay.
But that should be. So while I can't say that they shouldn't look at those covenants, they absolutely should, because if a landowner is deviating from those covenants, their other subdivision residents could sue them, but that would become a civil case that the county would not be a part of that.
Right. So covenants aside, we're looking at the subdivision application, and currently the only way, and correct me if I'm wrong, please, the only way to get your ADU, if you have to amend that subdivision application if your subdivision application is for one home, correct?
That is correct.
One structure. So you're going to have to amend it. Currently, the process to amend your application is going through a full subdivision process, which in our discussions seems to be, it's very cumbersome to have one ADU. And so I think we wanted to figure out a better way to do that. And I know that there's lots of issues there because there's reasons why we have the subdivision process and the review, and the reason why it has, that plat has to be amended. It's recorded. Like there's different things that go with that. So I guess, do you have any proposed ideas for how we can make that process just a little bit easier for people who are in a subdivision wanting to do an ADU?
Madam Chair, at this time, no, not really. Other than if DEQ were to not, and I'm not trying to change the DEQ process, but just to back up that train a little bit, If DEQ were not seeking planning department approval, this would be an irrelevant conversation, if that makes sense. Since we do not have building codes, we do not have zoning, we do not have building inspections, we, the county, would not be a party to this conversation. This would be a conversation to be had solely between the residents of that subdivision to work out whether or not it's allowable in their covenants. But the issue arises when DEQ seeks my approval and I cannot give my approval.
Okay.
So that, I mean, the only fix, and I don't know that it's a fix because I don't know the law or the requirement for DEQ to get planning department approval. So that may be a better question to ask Megan, if my approval is required, or is there a way to not get the planning department's approval?
Okay.
But amending a recorded plat, the only way to amend a recorded plat is absolutely to go through the subdivision process. And when I say recording a plat, that's actually, amending a recorded plat, that's amending the subdivision application.
Okay. I'm happy to ask Megan some stuff. I want to let the other commissioners chime in, but I think my thought too goes to, is there something we can do with that process that doesn't require, like in the case of, I want to amend my plat, I'm going to do a one lot minor, but it's a subsequent minor now, and so now I'm having to do a full hydrologic study in EA. That seems absolutely ridiculous for somebody doing one lot, right? That makes no sense. So, I mean, we can come back to that, but Commissioner Swenson, Commissioner Randolph, do you guys have any thoughts and questions?
I don't right now. I will.
As we're talking about it.
List, but
I'm trying to figure out how to phrase this. My one question. So, subdivision application is a document that is used to get the subdivision approved through the county. Once the subdivision is approved and it's filed, how controlling is the application at that point? I mean, because it was like I said, it was the document that was used to get it approved. Now it's approved. Now it's filed. And I don't know if you have that answer, if that's a Kevin question, or if it's a question to get answered later, but I was thinking about that last night as I was trying to sleep. But I was like, I guess how controlling is the application after the fact of the subdivision being filed?
Madam Chair, can I respond? Please. But then I do want to allow Kevin time to respond to you. But in my planning professional opinion, I feel like it's a very important document. Even though it's not a recorded document, I feel like it's very important because that was actually the catalyst that got it to the place of recordation and subsequently land sales. Without that application, it wouldn't have made it that far. And that application is the a two-page description of the development and what the developer's intentions are with that property when the property sells. So that's only planning department,
right.
My opinion.
So when it comes to the application gets approved, you have a certificate of subdivision approval, also known as a COSA. Title 76, Chapter 4, Section 130 is for deviations from the certificate of subdivision approval. And it basically says that a person may not construct or use a facility that deviates from the certificate of subdivision approval until the reviewing authority has approved of the deviation. There's an exception to that, which is if the deviation is just connecting to municipal, county water and or sewer district, which this county does not have any of those. So pretty much, from my understanding of this, is that if you're wanting to deviate from your certificate of subdivision approval, you're having to basically apply and getting permission from the reviewing authority. And so I think it's going to really depend on how much you're deviating, and I think ideally, if we could sort of make that to be as, I think amending the subdivision regulations to make that as quick and expedient as possible, especially for people, with the topic of accessory dwelling units, and if you're just wanting to add an ADU to your property, and that's the only deviation is from the coast, that's the only deviation, being able to sort of make that an expedited process instead of having to do an entire sort of subdivision application
Right.
to deviate from what's already been approved.
Go ahead.
Just to be clear, a COSA, it's very unfortunate that they use the same word subdivision. COSA is for the approval of the sanitation through DEQ. That subdivision has nothing to do with the actual land subdivision. So the certificate of subdivision approval is what DEQ uses to approve the sanitation. Same as I would have to get a COSA on a family transfer on any land that's not inside a subdivision. Anything under 20 acres, you have to get a COSA on before DEQ gives you approval. So this kind of, like I said, it's a unfortunate term because it's not necessarily affecting the subdivision approval because it's the DEQ approval, if that makes sense.
Yeah, and I think part of the problem is that DEQ is coming to us
right
for us to approve their approval.
right, which is how we kept getting into this
It's,
weird
it's,
this circle that was like,
Yeah.
how do we get out of the circle?
it's a chicken and egg situation. It's a lot like the water, honestly. It's the same situation as with the NRC and the water. Like, how are we as a board supposed to approve sanitation and, water quality? Why are we the ones doing that? I don't think we have the ability to say yes or no. Now, I would hope anyone adding another dwelling unit would want to have their sanitation lined out and have that done correctly. I would hope you would not want to be putting your septic in the wrong place, whatever, or that you have enough space on your property. I would hope that would be looked at just independently, but we've seen things happen. People do crazy things, so I get that. But I guess, Megan, if you will, I don't think, we know what it looks like to change a process, to try to change a process, and we went through that this year at the legislature with water. But if you will, can you explain that a little bit more?
Okay, Megan Bullock, County Sanitarian. So to start out, the reason we're in this mess is because under the Administrative Rules of Montana, 1736, 103, 1L, if planning and platting approval is required under Title 76, Chapter 3, which is, Nicole, that's the Platting Act, then the applicant must provide a copy of the approval and findings of fact and any public comments. So that's the piece that is causing us some problems. So if it's a family transfer, that's exempt from platting. However, it's not exempt from MCA 76-4, which is the Sanitation and Subdivisions Act. And so it's two different parts that sometimes involve Nicole, sometimes don't. So the ones we're struggling with are the ones that are in subdivisions that were subject to the Platting Act, and I now, under the Sanitation Act, need comments from her. So regardless of whether it's a subdivision or not, if someone's wanting to add an ADU, that will almost always trigger us to have to go back through the sanitation, through the DEQ, and get a rewrite of the COSA. The only exception, so it gets even more convoluted, the only exception is that under DEQ 4, we have definition of accessory building, which is a subordinate building on the same parcel devoted exclusively for an accessory use, such as a garage, a guest house. And then we have a further definition in DEQ 4 of a living unit, and a living unit is the area under one roof used for one residential unit, facilities for sleeping, cooking, sanitation. So for those people who want ADUs, the big question becomes, will this be an independent? Because we use that ADU term interchangeably, and sometimes it is an accessory building, and we don't have to do a new DEQ. But if it has facilities for laundry and kitchen, that's an independent living unit. We now have to go back through DEQ for a rewrite. And so that's causing a little bit of trouble too. Some people do have it as a guest house. As long as we have one septic, one well, we're still compliant with our DEQ COSA. So the problem, I think, is all under plating, because when it originally went through the subdivision review process, let's just take a 10-lot subdivision. The application said single family, so we have 10 new homes. If they all do an ADU, we now have 20, and you didn't have the opportunity to contemplate the impacts on roads, schools, fires. That's where the big problem is. I don't know a solution. That's Nicole's problem. I just need my ladder, okay?
What can be, knowing that changing, like, we're not going to change MCA, right? MCA is going to be what it is.
Yeah, and that is in the administrative rules, but
Yeah.
same thing, it's not an easy fix.
Yeah,
It's not going away.
It's not going away. And I mean, that's something that would have to be done legislatively at a much higher level,
Right.
during session, which we know how long that all takes. What is under our purview, like in our own regs, what can we change? What is adaptable? And I should have brought my copy of my regs, and I did not.
Tear the desk apart.
Amended applications. Nicole, is that the correct spot? 266?
Page 34, Madam Chair. Page 34 of our subdivision regulations talk about amending final plats. That section is solely for plats that have been given final approval, but these plats have not been recorded. So that's to say that the subdivision application has gone through my office, the planning board, public hearing if required, to the commissioners for preliminary plat approval. The developers met their conditions of approval and gone back to the county commissioners for final approval, but have not recorded the document. I can tell you that when a developer gets to final approval, in my 22 years with the county, they have very rapidly gone in and recorded that plat. So this is a very, very, very small window. This is pre-recordation, but the developer has worked so terribly hard to get to that point of recording. That's the pinnacle of the process. They want to get that recorded. Very infrequently do they wait, more than a week at the most, but sometimes even the same day. So all of that to say, that's a very, very small window of time historically, where this amending final plats can be used. If I can bring your attention, Madam Chair, and whomever else is looking at the regulations, to page 35, to the recorded final plats. This is where the final plat has been recorded. This means lots may have sold, homes may have been constructed, much has happened in that time period. So recorded final plats, this is set in statute and is almost non-amendable. And to record recorded final plats, I'm just going to read this section for the public's benefit. It's brief. This is Broadwater County Subdivision Regulations, Section 2B7, Recorded Final Plats, Sub-Item B. Any proposed changes to the recorded final plat require the subdivider to submit the new subdivision application or subdivision exemption claim application to the subdivision administrator for review in a pre-application meeting and pay a new application fee. Subdividers will schedule a time to submit the new subdivision application. So also I should have started with sub-item A of this section, but I'm going to read that as well. If a final plat has been recorded at the county clerk and recorder's office, there can be no amendments to the recorded final plat unless necessary to correct an error on the survey pursuant to section 76.3.4 and or section 76.3.614. So that's essentially stating that you can't amend it. And that's for the benefit and protection of anyone buying into that subdivision. If you bought into, let's say, a 10-lot subdivision, and you want to amend your subdivision lot, well, there are 9 other lot owners potentially in that development that should have a say in what's happening in their subdivision as far as an amendment to their subdivision. So it would be required that that person desiring to amend a subdivision and a subdivision application would have to go back through the process. So I see no other way other than to do a subsequent minor subdivision. And the reason I would be calling it a subsequent minor subdivision is because it's a subdivision lot that someone is desiring to amend that lot, so it's subsequent, a subsequent minor subdivision. I can also, agree with what Commissioner Chairwoman Rickmeyer stated previously, that it's very expensive to go through any major or subsequent minor subdivision process, and that a hydrologic study is required since it is a subsequent minor, and subsequent minors follow the same process as a major subdivision in their environmental assessment requirements.
And you're saying this is all, well, this is MCA. I see that pursuant to section MCA. So no amendments to the recorded final plat unless to correct an error. So that basically just says, sorry.
Maybe a misspelling in the title, or just an error on the plat. Yeah.
County Attorney Bratcher, I'm putting you on the spot. Do you have any thoughts on this? Sorry to put you on the spot.
Unless the county wanted to adopt countywide zoning regulations so that we would fall into the purview of Senate Bill 532, doesn't seem like there's a good feasible option.
And I'm sure zoning, everyone would love that and be really supportive. Be no problem at all. Okay.
Question.
Yes, please.
Could you explain the BLR process, the building for lease or rent? I mean, because correct me if I'm wrong, but I think if they went through that process on one of these lots, it would not trigger an EA. I might be wrong, but
Madam Chair, can I respond?
Yes, please. Sorry.
No, don't be sorry. Commissioner Swenson, I would need to take a little more time to review our BLR regulations. I can certainly explain the BLR process, in that BLR stands for Building for Lease or Rent. We do have regulations, BLR regulations, that the county adopted either 2013 or 15, sometime in that time period. Anyways, we do have those regulations, and that allows for however many accessory dwelling units to be on a certain piece of property, in the sense that the landowner owns the land and the structure. So it's building for lease or rent. So the property owner owns the dirt, owns the structure, is renting the building or leasing the building. I do not know how that would work in a subdivision, whereby the subdivision application, so kind of this, like, circling back, if the subdivision application stated that the lot was for one single family residence only, I don't know how someone could amend that. I have given that some thought, but I don't know of a way forward for a landowner to amend their subdivision without going through this section in the regulations for amending a recorded final plat. So I don't know that a BLR is an option in a subdivision that is approved for one single family residence per lot.
Family transfers are now allowed, right, in subdivisions.
Yeah, they are.
That's across the board. Oh, yeah. But that's a different step. Story.
And Madam Chair, can I add to that statement? If a parcel of land, yes, any lots now in a subdivision or out, the family transfer exemption can be requested. But the requester must provide a copy of their covenants, and the covenants must allow for it, because
That's right.
the commission will be the ones granting approval or denial of the use of that exemption, the family transfer exemption. but you need to ensure, and part of my job in presenting that exemption to you is to prove that the covenants do allow for further division of land. So if the covenants do not allow for further division of land, I can certainly still bring you the exemption, but it makes it hard for you to say yes.
Yes, no, thank you. I forgot about that little, the covenants. The covenants.
May I ask a question on that?
Please.
This is probably to Kevin.
Please.
If the covenants say you can't split it, and somebody comes to us to ask for family transfer, how can we deny it based on the covenants? Because isn't that in fact enforcing the covenants?
Yeah,
Oh my
that's
gosh.
kind of my sort of view on it is that is in effect the county enforcing the covenants, and I would think that it would be sort of like us as the county, we're approving it, but just there's nothing that just because we're approving it doesn't mean you're going to win in court if your neighbor sues you to stop you. 'Cause especially when it comes to
I
that
know.
specific issue.
Right.
I don't see how that wouldn't be considered the county enforcing the covenant.
Right.
And because I know we frequently have issues where people in subdivisions want us to enforce all sorts of different covenants.
Mm-hmm.
And I don't think we want to start enforcing that covenant just because it is a part of the review process.
Sorry, didn't mean to go down that
No,
rabbit
that
hole
was going to be
too.
my question. I was scared to
Oh my
ask
gosh.
it, so thank you, Jessica.
Yeah.
Okay, Commissioner Swinson.
Yeah.
It's like we're enforcing it, but we're not. In real simple terms.
We're not enforcing it in the way in that
Yeah.
we're filing a lawsuit
Right.
to stop somebody, and our only legal basis is that you're violating the covenants. So it's not directly
I know.
an enforcement, but it kind of is semantics at that point. We're
Right.
enforcing them in a roundabout way.
Yeah.
Can I add on that?
Please.
And conversely, they are now a party to the deviation from the covenants if they allow it. Would that not be true? If they're approving the family transfer when the covenants state no further division, I guess that's maybe I don't want an answer because that could be I mean, I'm just saying, like, if it did end up in court as neighbors suing neighbors, could the county then, I'm not asking you to answer this, this is
Be
putting
party-
it out there into
be
the universe,
party there.
could the county then be a part of that lawsuit because you participated in the deviation? But don't.
All the rabbit holes that we can go down. That language on the amending the recorded plat is just really restrictive. And I was hoping that we could find something to put into our language that would allow for that process with the ADUs, but that's very, very restricted. And that's MCA. I'm curious how other counties are going around this, or not around it, but or how they're handling it, and what's happening. I'm very curious. Do you have a thought? You were gonna
Well,
say-
I'm just, my question kind of keeps going back to what is the controlling? Is the application controlling? Because you're not really amending the recorded plat. The plat was recorded for residential use. The application might say single family. The plat does not say single family. Very rarely. I'm not saying it doesn't ever, but it's pretty rare that those restrictions are on the face of the plat. So adding another residential unit really doesn't deviate from the plat, it deviates from the application.
Okay,
Yeah.
that's a good point. I mean, I guess. What are your thoughts?
Can I jump in here? I
Please.
know Nicole and I discussed this a couple days ago. So let's just use the 10-lot subdivision. I buy a lot there. I believe there's supposed to be one living unit per lot. It may not be in the plat, but that's my understanding. And now we're changing that. I can just see I can see both sides.
Absolutely.
And to me, that's where the covenants do get enforced
Yeah,
by
exactly.
by the residents of the subdivision. I don't know.
But covenants are only as good as that group,
Yes.
as we all know.
And
Absolutely.
HOAs disband all the time.
Right,
so,
right.
yeah.
Yeah.
Some are very good, some are non-existent. Existent, but not
Yeah. They're
active.
still registered,
Active,
but they're not
right.
active, yeah. So you're thinking, like, how could we amend the application?
Well, you can't amend the
Well, you
application.
can amend the application, but how do
Because
you?
that would, and I'm not saying it's not still enforcement, or the controlling document. It's a question, is at what point, or is there a point when the application is no longer controlling after it's filed? Or is it always in controlling no matter in perpetuity type of a deal? And I don't know that answer.
The application, so if it's for one structure, and it's reviewed by DEQ for one structure, right? And then that DEQ approval or review is on the plat. Is that correct?
It's recorded with it's a separate document.
Okay, and so that's technically
But
what would have to.
It's with it.
It's with
Right,
it,
it's
yeah.
with it, but that's technically, it's the DEQ approvals that would have to change and be attached to the plat, the recorded plat, right?
You're asking me, Madam
Yes,
Chair?
sorry.
Okay. No, that's okay. Yes, so the DEQ rewrite is what it's referred to as, so amendment to the DEQ approval is subsequently recorded with the plat. So in our clerk and recorder's office, we refer to them as plat envelopes, and that's where the plats are. They're actually stuffed inside. They look like big Ziplocs, and inside that big Ziploc with the actual plat is the DEQ approval, along with any subsequent rewrite, among other documents that legally need to be in there. But yes, so they are recorded with it, not on it, but with it.
So, just throwing stuff out.
That's what we're
Just throwing stuff out. If you have if the DEQ approval is what needs changed, not necessarily the plat, right? You're not changing the plat. You're not altering the plat. You're not altering the initial application. You're simply altering the DEQ approval. So then, is there a process to alter? Could we have a process lined out, like a county process, to amend that DEQ approval for an additional space, as long as that DEQ approval gets amended and put in with the plat?
But aren't you, if you do that, aren't you amending the application?
No, because the application, like Jesse's saying, the application's already done. The application got us to the subdivision.
Right.
That's what the intention was. I guess I keep going back to, like, okay, I'm gonna do my application. I've got my spot, whatever. I don't know what's gonna happen in 10 years. Maybe I want to build a house, for my kid or whatever. I mean, how there has to be a way to maneuver around that, because nobody's gonna know that all the time, like what's coming in the future, what's coming down the pipeline. And in the case of an ADU, hey, my mom needs a place to come live.
I get it.
Right? And so it's like, we want to go through the process, DEQ. It should have nothing to do with, it seems like it should have nothing to do with the application or the plat, as long as the correct DEQ and sanitation is with the plat.
So does that negate any comment or instruction from Nicole then? If the DEQ is asking her to approve it, what does she approve it on?
That's what I mean. We
Yeah.
would have to find a
Yeah.
process
Okay.
on our
Yeah.
side. Yeah, we'd have to find a
Yeah.
process within our regulations that allows, because you're not amending the plat, you're just
Right,
amending
right.
that form that's attached to it. So we would just need to figure out a process to do that within, like, what do we need to know on our end to approve that ADU? And that also gives DEQ what they need. That's what I'm thinking.
Yeah, absolutely, Madam Chair. If I may, the problem, obviously we all know the problem comes when I am asked to give approval. What am I basing my approval on? Currently and historically, I've been basing it on the subdivision application, but if there's another way or something else I could be basing my approval on, or disapproval, I mean, I guess, there could be an instance where it's disapproved, but to give my approval, where do I look? Should I not be looking at the application?
If not, then what do you
Then
look at?
Yes.
Would
Is
it,
that-
Correct, yeah.
would it be possible, like, to do, whether it's a resolution or amend the subdivision regulations to allow this or something, but to set up a process, like an application process, where they would come, put in all the pertinent information, and it might be even having to have a public hearing type of a thing where we're informing the surrounding landowners or something, that they would come to us and we would go through that process, and then we would base the approval off of that decision.
That's what I'm saying. And at that, if with that type of I want to say flexibility, if it's our own process that we are adding, right, then I would think we would have the ability to say we can do this for one ADU, not 3, but one ADU, right? This isn't a BLR. This isn't. You're not going to do like a compound, right? We do this. This is like a one-time thing, and we'll allow for it. And I mean, I guess we could, and this is more to be discussed, but I guess we don't want to be in the middle of covenants. We don't want to be regulating, enforcing anything with covenants. Could we still say you need to check your covenants, just like as a preemptive, like we don't want to end up in a big storm of stuff, like covenants need to be checked prior to submitting this application.
Yeah, commissioners, I think that if we were to, we'd need to find our authority to create a new application process. Because what are we basing our approvals on? Approvals or denials, right? If you are going to have the authority to approve, you have to have the authority to deny, and you have to find your authority. So to create a new regulation to allow for ADUs, or a new application process, but there would have to be a regulation that would govern that application process. So a new application process for ADUs within a subdivision, I absolutely think a public hearing should be required, and all subdivision residents notified, not just directly adjacent landowners like we have now in statute for public hearings. I think that might be a path forward, but yeah, you're absolutely right that the covenants, because
Like, why even go there if you know it's going to turn into a storm of whatever?
yeah,
Just
and the landowner
have
would have to look. I shouldn't say. Yeah, maybe this is. We'd still have to find our authority if the landowner should or be required to. Right, those are the two options: to amend the covenants to allow for an ADU, if the covenants do not allow for it, or do we just ignore the covenants? I think both of those are horrible options.
Yeah.
But I like the idea of a new application process for ADUs specifically, but we have to have some parameters for that to allow you the opportunity to say yes and subsequently the opportunity to deny if that ever was necessary.
Agreed.
But the way we have it written now does make it terribly difficult, and yeah, and so we just kind of keep circling the drain here in the sense of if we're amending a recorded plat, as Commissioner Swenson stated, what authority does the application itself actually have?
Right. Because the application is serving a purpose at that time.
Correct.
To guide in that process at
Right.
that time, right?
That-
After it's said and done.
Right, but that's what got it to final.
Right.
Sure,
Right,
sure.
that's-
I guess, Megan, would you mind coming back up? If you, what would be your concern, or what would be your priorities in an application process? that we would come up with for, to be able to give DEQ a clear answer.
Yeah, so most generally, any time that something meets DEQ requirements, it's good. So I wonder if we can somehow, and I was just trying to look and I cannot find it, but what is it under 76.3? There's the sanitation section. Is it, I keep wanting to say 9, I can't remember where it's at exactly, but it's pretty detailed in what needs to be submitted with a subdivision that has to do with water, wastewater. Maybe it makes sense to have them submit that first as part of the application process, make sure it works with septics, wells, and that would be part of your criteria.
Okay.
Did you find it, Nicole?
I think 76.3.622, water and sanitation information to accompany the preliminary plat.
That's it.
Okay,
Yep.
76.3.622.
76.3.622.
622. Okay, yes, ma'am.
I personally think that public comment is going to be a big,
Yeah,
I think
absolutely.
you need to somehow
Yes.
have that as
Absolutely.
part of it. But if there's a way that we just include that as the review process, I think you would be okay. I mean, that's all being reviewed anyhow as part of the DEQ review,
Right.
so it's not anything additional that
Right.
would have to be done.
Because really, if they can't get DEQ approval, it's a moot point anyways.
Exactly.
Exactly.
Right,
It's a very good point.
Yep.
yeah,
Start there.
my opinion.
Yeah. Thank you.
Good, yep.
Thank you.
Madam Chair, can I ask
Yes,
a
please.
follow-up question of Megan?
Yes, please.
So Megan, just because I want to be sure I'm capturing this appropriately, you're thinking that for an amended application process, or to, let's say, to allow for an ADU process, let's call it that, they would need, you think that maybe we can suggest or require that they comply with 76.3.622 right away, correct?
Right.
Okay,
Yeah.
perfect. I know that that's what you said, that's what I heard, I just want to make sure that,
Yeah, I think
I
that's
understood
a
that
starting,
appropriately.
I think
Okay.
that's the meat of what we
Mhm.
would want to see to know if it can be done. I am a DEQ contract reviewer, and so I'm actually the one who reviews all the submittals. And so I would know by looking at what they submitted to Nicole, whether they met the requirements and would be likely to get approval through DEQ.
Okay.
And you could have it contingent on the approval too.
Thank you, Megan. Commissioners, did either of you have anything else? Some additional thoughts, questions?
I'm sure I will.
Mr. Ratcher, did you have anything else you wanted to throw in?
No.
Does that, no. Does the idea we're thinking of seem to be something that would be legitimate? Like we could form our own process for this?
Yeah, I think so, because I think ultimately, I think for what the county's concerns are going to be is, since we don't have county water sewer facilities, it's from a sanitation point of view, making sure that adding an ADU 1 or 2 or 3 or whatever in the subdivisions where that is happening, so we're just making sure that we don't run into any water quality issues, and then being able to keep it, the sanitation aspect of it. I think it's either doing something like this to where we're incorporating an application process through our subdivision regs to allow for an expedited and efficient way to do this, or adopting county-wide zoning regulations.
Right, right.
Because we adopt the county-wide zoning regulations, then we have SB 532, which tells us what to do.
Which is interesting because SB 532 is like, doesn't matter,
Yeah.
just do it.
Yeah.
But I think in 532 you still have to have covenants, right? Your covenants still have to align with an
Yeah,
ADU.
SB 532 does not override any existing covenants between the landowner, the subdivider, and subsequent purchasers and landowners, because that's a private contract. So there still is always going to be that issue of if the covenants in the subdivision do not allow ADUs. That's, if I lived in a subdivision that did not allow ADUs and I wanted to put an ADU on there, I'd be, running the risk of getting sued, losing, and then being out all that money, regardless of whether the county approved it or not.
So something, if we come up with this process, something that says, step one, verify your rules of your covenants, verify your covenants and what is allowed. Having that on there as a checklist, is that enough? If their applicant's like, yep, checked it, we're good, is that enough to cover us as a county in that decision-making process? Like, hey, yep, they said they checked it, we stay out of it completely. Because again, we're trying not to enforce covenants or be involved with covenants, so.
I think possibly having something to where they certify that they check their covenants and the covenants don't prohibit this, maybe having something like that, but also if the person does not want to check that box or initial next to that, also not denying it as the basis of that.
Not denying the application.
Yeah, because we deny the application because they're not certifying that it goes against their covenants, then.
Oh,
are
okay,
sort
we
of
just
in a
know, but we know
position
where
of
they stand,
enforcing,
yeah, okay. It's basically showing that person, hey, you said you checked your
Yeah, you
covenants.
did your due diligence, and
okay.
Our approval does not override any covenants to the contrary. Maybe having language like that, so that, because we don't want to be enforcing covenants, but also we don't want to be getting dragged into a private dispute in a person using our approval as the basis for, as a defense in court. Whether that be us being the county being joined as a party, or Nicole being dragged in to every
Right.
property dispute to then your professional witness, which would be where you want to spend your time.
Madam Chair, can I ask a question
Please.
of Mr. Bratcher? So my thought process on this, I absolutely understand what you're saying, and yes, I want all of us to stay out of your floor of the building as often as possible. How do the commissioners and myself review these applications then? I suppose I hear what you're saying, that if they're checking the box, but to compare that to SB 532, which I know we are not required to comply, or we can't comply with because we don't have zoning, but SB 532 says that covenants supersede. So I'm just curious how, it feels like it's going both ways. So this new legislation is saying that in order for these ADUs to happen under SB 532, you have to, you commissioners, planners have to look at the covenants and they have to supersede. But we're writing our regulations to state conversely, in the sense of, we are not forcing you to comply, we are just going to strongly encourage you to comply, and you're going to attest that you are certifying that this application meets covenants, but county staff is not certifying, nor the commissioner certifying. In fact, we're not even going to look at your covenants because we don't want to be a party to that. Is that going to cause an issue later on? I don't know if my question or my statement makes sense. I mean,
It makes
it's,
sense.
this new law is stating that planners and commissioners need to look at covenants. We are going to be potentially writing new regulation or new application process that says we're not looking at covenants. Is that okay? Because we're drawing up our application process and subsequently a version of regulation that will be similar to what SB 532 is creating, but not complying with because we don't have zoning.
So SB 532 doesn't say that, I'm trying to phrase it this way. SB 532, specifically the new section, is a limit on what county governments can do. Specifically for new section 1, subsection H, says, in jurisdictional areas where the Board of County Commissioners has established zoning regulations under this part, the regulations must allow minimum, so that's 1A. Then you go to 1H. Actually, it's not even 1H, it is 2H. So go to subsection 2, a county may not require a restrictive covenant concerning an accessory dwelling unit on a parcel zoned for residential use by a single-family dwelling. This subsection may not be construed to prohibit restrictive covenants concerning accessory dwelling units entered into between private parties, but the county may not condition a permit, license, or use of an accessory dwelling unit on the adoption or implementation of a restrictive covenant entered into between private parties. And then if you go down to subsection 6, the provisions of this section do not supersede applicable building codes, fire codes, public health, safety regulations. So it's saying that the county cannot require subdivisions or property owners to have covenants that restrict ADUs, but also that's if you're a county that has zoning regulations.
Right.
But it also says in that 2H, you can't require it, you can't prohibit restrictive covenants concerning, it's just the county government, SB 532 doesn't have any impact on covenants, which is when during the legislative history, when there was a discussion about opponents to this bill or proponents, sort of the concerns of, like, let's say a subdivision that has 10 plats, each one of them adding an ADU, and then you now have a 20-home subdivision that was originally supposed to be 10. The solution to prevent something like that from happening was that if the subdivision has covenants preventing that, this law doesn't have any effect on that. It doesn't override those covenants, but also the county isn't enforcing those covenants because the county isn't a party to it. If that makes sense.
Clear as mud.
Yeah.
If I may, I have a question.
Yeah.
So we're saying these don't apply to us because Broadwater County does not have zoning. And this is amending the section on zoning, correct? Is that?
Yeah, so section 1 of SB 532 is a new section under 76 Part 2, Title 76 Part 2.
So section 5 on here, it says a county that has not adopted or amended regulations pursuant to this section by such and such date, shall review and permit accessory dwelling units in accordance with the requirements of this section. So I guess I'm confused why we don't fall into this. If it's saying a county that has not adopted it, you still fall under this.
So that is a county that has zoning regulations, but has not adopted regulations concerning ADUs. Because initially, that was my view of it as well. But after with talking with Mako, it's because this new section is in the Title 76 Part 2. And this county doesn't have any regulations pursuant to 76 Part 2. So, like, let's say if we did have zoning regulations, and currently our zoning regulations stated if you're in a residentially zoned area, single-family residential zoned area, you can have one single-family residence. On October 1st, when this law goes into effect, that regulation would be void, and it would be, you can now have an ADU. But because we don't have any zoning regulations, period, we don't have any, this doesn't affect us because theoretically, you know, we could have whatever, we could allow the ADUs however we sort of wanted pursuant to the subdivision regulations.
Which is, I guess, a good problem to have in some ways, depending on how much you want on what burden you want on us. But I mean, it allows us to form a process, is what I'm trying to say, as opposed to being dictated to by the state.
But as Nicole said, we have to have the authority to establish the process. And if that's not in MCA, then we really can't.
So it sounds like research needs to be done.
Yeah, I mean, totally.
Before we can even move forward.
Because you could say if it's not an NCA, you could say it doesn't say we can or can't, right? So,
And in subsection 5, when it's saying pursuant to this section, it's talking about Title 76 Part 2. Or Title 76, Chapter 2.
I need to look this up. I don't think I have one of the amended bills, and it doesn't have the section 5.
Because Commissioner Swenson, initially, I had the same view as you, is that, well, if you don't have any zoning regulations concerning ADUs, then this applies. But that's when, you know, Mako was of a different opinion, because if you don't have any zoning regulations, period, then the new section that is in SB 532 doesn't apply to you because you don't have zoning regulations, period.
And I believe that came down to the very last section of this bill, the codification instructions, that require this law to go into Title 76, Chapter 2, Part 2. Part 2 is county zoning. And so that was I suppose, the most clear instruction. But yeah, because Kevin and I met and discussed this bill
'Cause
at
I-
length.
Yeah, because I initially was like, well, this is
Right.
easy answer. We don't have
Right,
zoning
right.
regulations, so we'll just go off of this. But since we don't have any zoning regulations, period,
Right.
um,
It's not applicable.
yeah.
Typical writing the law. We thought it made
Mhm.
perfect sense.
Mm-hmm.
So commissioners, can I propose a potential solution
Please.
that I almost don't want to put out there because it's creating more work for me, but this is a very, I say that jokingly. This is a very worthwhile topic to consider. In fact, prior to Commissioner Swenson coming on staff, Commissioner Rickmeyer and myself and Megan met, and then Commissioner Randolph and myself and Megan met to discuss this very topic about a year and a half ago. To kind of get an idea of how we should proceed as a county. So all of that to say, this is going to be happening more and more. We are all very aware of the land prices and the home prices in Broadwater County. We, as employees of Broadwater County and elected officials of Broadwater County, we do want to be working very, very hard for the people of Broadwater County to come up with a solution. So when we identify a problem, we are obligated to work towards a solution. So all of that to say, I think what I'm hearing today, a possible solution is to come up with an ADU application process. So I can do some work on that, working with other counties, obviously working very closely with Attorney Bratcher. I can reach out to MACO, Montana Association of Counties, and see if they know of other counties that maybe are doing something similar, and see if we can come up with a solution. I'm not going to put a date on when this will be done because I do not know what that looks like. This is the whole purpose of this meeting today was for all of us to work towards a solution and be able to have and engage in a public conversation. Moreover, CU commissioners could be engaged in a conversation with each other because, as you know, and the public may or may not know, you commissioners are unable to discuss a topic in private. All of this has to be done in a meeting. So I greatly appreciate you holding this meeting today so we could talk through this. So I can do some work on coming up with an ADU application process and see if there are potentially ADU regulations out there that other counties are using, and get some best practice tips. And obviously, like I said, working very closely with our county attorney because these all need to be legally defensible by him. Every decision that you make and every application or process that I put before you needs to be legally defensible, so we are not creating more work for him and his staff.
Especially while our chief deputy county attorney is gone. That's a lot. Is there anything else from anyone up here? Because I do want to ask for some public comment and get people's thoughts if they would like.
Is it possible, like if we decide, if we chose to go this route, that basically we did a county-wide zoning that just adopted 532? So we fell underneath of it? Not saying we want to go that route. I'm just throwing an idea.
So adopting county zoning.
Yeah.
So then,
But basically the zoning would just apply to the ADUs at that point.
oh, I see what you're saying.
Can you do that?
I don't know. That's why I asked.
Oh, okay, I'm like, can you do
No.
No. Ken's like, a good talk. No. No.
We're looking for an easy
You don't know
answer.
unless you ask.
Yeah, because it's 76.202 is sort of the statute that governs the establishment of zoning and So you have to, establishing the zoning districts and then having sort of regulations like the subdivision regulations that govern sort of the requirements for whether that's going to be like an agricultural, residential type zoning and enforcement. So also it has to be promoting the purposes of public health, safety, morals, and general welfare. You know, it's, so it sort of probably be a little bit more in-depth and complex than just trying to do like an ADU application. But if we did do that, it would at least sort of solve this ADU issue.
Okay, anyone else? Okay, is there any public comment? We would love to hear some public comments.
Madam Chair, Commissioners, my name is JJ Connor of JJC Consulting LC, and that's JJ Connor, C-O-N-N-E-R. So, thank you for holding this meeting and taking the time to go here. You know, I'm born and raised in Montana, and obviously, like you guys, I've seen the housing prices go up tremendously. I have a daughter that someday I'd like to help out if possible, because it's pretty difficult to afford a house nowadays, or land. Broadwater County is sandwiched between two counties that are very high expense, one being Gallatin, average home price $800,000 plus, Lewis and Clark, which has pretty much doubled to $500,000-600,000. You know, a lot of our people in Broadwater County work here, live here because they want to, but it's also close enough that they can partake of some of the job opportunities. So I think that some of the discussion is great today. It seems to revolve around the fact that we need an approval from the planner for some of the DEQ, and I think there's a lot of maybe ideas and maybe even confusion on some parts that I want to try to just talk about. One of the things is that DEQ doesn't care how many houses you put on a lot, right? As long as you can fit them on a DEQ parcel, as long as you can meet non-DEG requirements and all the state requirements for DEQ, you can put as many houses on a parcel of land as you want. The county is, at times, is the one that construes that through covenants, perhaps. I think that SB 532, maybe MACO's misinterpreting that, similar to they did the DNRC water rights for the 10 acre feet. I think that 5 actually maybe does apply, and I think something to keep in mind is this bill, if you listen to the intent of the legislature when they're talking about this, I listened to the audio, the intent was to amend, you know, this bill is to amend this to apply to counties. And I realize there's some discrepancy. I mean, we have state legislators that don't always understand everything perfectly, but the intent to me when I was listening to that was to allow a second ADU. And I want to point out that this expires in 2029, right? So this isn't a permanent thing right now. This is a 4-year, I can't do math, bill that is to meet that need that Broadwater County, Lewis and Clark, and others have to go forward. And I want to point out, you know, in part of my work, specifically recently in Lewis and Clark County, I've not taken 2 jobs because there was no way that that lot could meet DEQ requirements and for the ADU. So if a lot can't meet DEQ requirements, maybe that lot can have one, whether that lot's 19.99 acres in size, but maybe there's a water source nearby and we can't pass trigger value. I mean, there's hundreds of rules with DEQ that you got to meet and require, and I think that's the overall scope of the issue here is that by meeting DEQ requirements, you're providing water quality and quantity protection. You're providing you're doing non-DEG to make sure you're not going to have cumulative nitrate effects that's going to potentially affect someone's well downstream or drain field or whatnot. You're going through the county to get your septic permit. I think that this act or this provision here, I think it's just being looked at a little wrong. I think that it's actually in the title to requiring counties to adopt certain regulations in relation to accessory dwelling units. Once again, I'd go back to the intent so the county doesn't get crosswise with perhaps the governor's office or whatnot as far as what the actual intent of this bill was to require a second dwelling unit. And I think part of the reason this bill was passed was to not have to go to the county through DEQ for that approval. And this is why it ends after 4 years too, because it's something to help our youth and elderly to be able to add a second, you know, dwelling unit, regardless of covenants. You know, with Dry Creek, that was one of the subdivisions I was working on that some of this discussion arose from. And I would argue that the application is the application, right? Kind of like the COSA. The COSA is meant for DEQ, Certificate of Subdivision Approval. And when that COSA is approved, I can go back any time and do a rewrite as long as I meet the certain non-deg rules and requirements perhaps with covenants. But with the county approval, you know, many of these, I'm not saying everyone, but many of these don't specify a single-family home. They specify residential lots. So you guys' own approvals that you've been approving for years and years, the several I've looked at that I had in my purview just say residential lots. It doesn't say you can only have one. So that's maybe where the covenants come in. So I think we're looking at this perhaps a little wrong in the fact that, you know, what was the intent of this law? The intent of this law was to provide some relief and the ability for people to add a second family dwelling, whether it's for their kids or some elderly, to be able to live and work in this county and live in Montana as opposed to moving out. I think that, you know, one of the safe backs is, yeah, DEQ, you got to meet DEQ, and there's lots of projects I take. Some of you have been aware of a few of them that I can't get approval on because it doesn't meet DEQ requirements. And most of the work I do, I've done some bigger subdivisions, but most of the work I do is family transfers, actual lots that never went through sanitation, so we're lifting sanitary restrictions because someone unfortunately buys that not knowing better, or adding a second ADU to that. So I just want to point out that it seems more of you guys are county's kind of focusing on this issue, but you got the bigger umbrella of the DEQ making sure that this is going to meet all state requirements and that we're going to protect water quality, quantity. We're going to do the non-deg calcs. We're going to, you know, protect the environmental we're going to meet the environmental requirements. And I think that that's the purpose of SB 532, and I would recommend going back and at least kind of trying to go through those boring hours of tapes and kind of listen to some of the intent of what this was for. And you know, I'm definitely not a lawyer, so what I'm saying doesn't mean anything, but
You're doing a really
think
good job,
that
though.
five is, I think this bill could be interpreted maybe a couple different ways, so I'd be cognizant of that. And I think that 4 years could buy you some time to put up an ADU regulations like Nicole was talking about, which would be great to help you guys when this, you know, if you were to adopt this, to help you guys when that happened, to be able to continue with adding that under and meet the requirements of both Broward County and the state. So I didn't follow my notes at all. I think I said everything I was supposed to say. But I just wanted to kind of point out, I think we're kind of going down rabbit holes that maybe you guys don't have to, and maybe there's some help here with 532, and there's a need in this county, right? I mean, there's a need for good development, allowing the second ADU or whatnot, and in addition, I argue that the application is a starting point, kind of like the COSA. The COSA can be changed, but you guys' approvals, you're finding of facts. The ones I looked at, I'm not saying it never says it, but the ones several I've looked at, just say you know, residential lots. It doesn't say anything with single family. So I think you guys have a way to make this work, and there is a sunset on this too. So, anyways.
JJ, what do you think about, like, I mean, I appreciate everything you said. Thank you. I guess we get hung up, and maybe it's because we're a little gun shy just after all the water situations. But the process of, you know, us saying okay, even let's say we go under 532, we say okay to something. It'd be so nice, much nicer if DEQ was like, hey, you guys can say okay, it meets all the requirements. That process, though, I don't think will change, because right now that's a non-issue. You still have to, even under 532, the county still has to be the one to say, yep, guys, we're good, go ahead and do your thing.
Of course, with 532, we, the county, say this is fine.
And then DEQ would say, if something's off, DEQ will say, if something's off, we can't do this.
Yes, DEQ has certain requirements under state law, and of course, DEQ, the last several years, the last two legislators specifically, has undergone a lot of change, right? I mean, the DEQ subdivisions. DEQ's umbrellas, air quality and water quality, but subdivision specific is what we're talking about, has undergone a lot of law changes to help improve their timelines, solidify the way they review stuff, and they've come up with new non-degradation rules. They've come up with a means value, with trigger value. I mean, it's helped make this a lot clearer on their end. So from my working with DEQ as a consultant, what I've seen is, yep, if, you know, we need that okay from the county, but as far as we're going, we don't care if you put one house or 16 on here, you just have to meet our requirements. Now, me, it's like, well, I can put 2 on this lot, that's all I can fit, you know, or whatever the case is. And that's where I think that, you know, the accessory dwelling unit law was, when I listened to it, was meant to apply to counties and a larger term, not the term of zoning, and that it was meant to provide some relief for the residents. You know, most are in the bigger towns. I'm sure Garfield County isn't having this discussion right now, you know, but that's where this act came about. So I just would caution that we don't get crosswise with the intent, and we try to move this and that there is a sunset. Sorry, go ahead.
It's okay. No, you're
Thank you.
good. Did anyone have questions for JJ?
No, thank you very much.
Good.
Thank you for your time.
Good thoughts. Thank you. You didn't even need your notes.
Right.
You were good. Yeah, you're good. Is there any other public comment? And please remember to state and spell your name, just for the record. Thank you.
Hi, I'm Mary Heineman. Mary, M-A-R-Y, Heineman, Heinemann. And I just wanted to come up and reiterate what JJ said. I believe the bill goes for all counties in Montana, and it does state that counties are mandated to allow 1 ADU. And it doesn't say may allow, could allow. So, and I agree with you, Lindsay, that you're not modifying the final plat. You're modifying the sanitation that goes with the final plat. And also, my covenants do not say single-family home. They say residential lot. And when you're doing subdivision, I believe you're either doing residential or commercial. It's not a single-family home. So, okay. Thank you.
Thank you, Mary.
Thanks, Mary.
Is anyone else? Any comment?
My name's Rick Neighbor, N-A-B-E-R. I don't know what else you need on that, but so I guess I'm one of the bad examples, story of my life. My son and daughter-in-law bought a house here in town. The rent went up like $350. They gave them like a 15-day notice. So instead of we're like, man, what do we do? Because they can't afford it. I have 4 grandkids that live with them. So we said, well, we just move them. You know, maybe we move them back to our place out there in the silos where they'd lived before. They had the opportunity to buy a place. Hindsight, they shouldn't have bought it, but they did, you know, and then they had the rent. So, you know, like everybody else in Broadwater, they can't afford, you know, an extra. When you do a budget, you know, you like what you make and everything else, food and all the rest of that, and then all of a sudden somebody throws a wrench in there and like, oh, now you got to pay $350 more. I don't know what the average prices are, but I know when the covenants or whatever for where I live were written back in the 70s, I'm pretty sure they were probably a little bit cheaper than they are now. But so with the whole thing, we started the whole process. We talked to the planning, and she gave us a copy of the covenants. We read through them, and we fall under a lot of those restrictions. I think the law was written to give ease from those instructions. As far as, you know, we're like JJ was saying, it would be nice to have where your kids could have a piece somewhere to stay, but unless your last name's Gates, I don't think you can probably afford to buy, you know, anytime you want to go buy a place and have your family taken care of. So I just, how the law is written, it just says requiring counties, and I'm not a lawyer in any way, but it just, to a simple man, it seems like the law is trying to help everybody out. It does have the sunset on there, so it's not forever. But it's we started the whole process. We talked to planning, we talked to sanitation, we talked to JJ, we talked to everybody else that would listen to us and try and figure out something. So anyway, we thought everything was approved after talking to the planning commission and sanitation, and it started having, JJ came out and we had a test pit dug for the septic, you know, where our property was. JJ said where it was recommended. So we had a test pit dug. He came out and started that part, looked at the soil. So we were planning on having everything ready. So come the 1st of October, we couldn't get the permit until the 1st of October when the bill goes in effect. But I was trying to, because of weather and time and everything else, we're trying to get everything done like preloaded. So when the 1st of October came, we could just take the permit, get the permit, and then, you know, have whoever's coming out and do the septic system. And, you know, try to do it all legal, everything we tried to. Obviously, then we got the news, we already moved the trailer out there because the lot rent, like I said, where my son and his family were. So we're trying to save them, you know, otherwise they're stuck. So anyway, we moved the trailer out there. We paid for that. We paid to have the starting JJ come out and do his stuff and everything else. So, like I said, we're trying to do it all legal. You guys get that letter my wife sent? I don't know if you guys saw that.
Yeah, the email.
Yeah.
Yes. Yeah.
So she's a lot better at wording stuff than I am, but she's unfortunately not able to make the meeting. So anyway, just so we have the expense of, we even started, we got the trailer out there trying to put a gravel driveway and, you know, to make it all easy before weather hits and everything else. And then now we're kind of at a standstill. We have the trailer for storing it for a year until we figure out what else we can do. I'm hoping that we can somehow figure out the law, so we don't have to move it again or just make it a yard art or something sitting in the middle of the field. That's kind of where it's at right now. We don't know what the step is to do next. We're trying to do everything as legal as possible and make it all right. I totally understand the covenants and all the rest of that, but like I said, when those covenants were written, I don't think people were paying $1,000 a month for rent in a 1-bedroom apartment. I'm an old fart, retired from Marine Corps and everything. I work at the school, mainly because my wife doesn't want me around the house. But I'm certainly not doing it to make money. But I certainly always want to take care of my family. And in the current situation, I'm at a roadblock. I don't know what else to do. So whatever you guys decide, hopefully we can figure out something. I think there needs to be some kind of, there's got to be laws for everything. But it should be fairly simple, especially with 532. To me, it says it's for all, requiring all counties. It doesn't say except for, you know, if yours starts with a B or a W or whatever. It just, you know, it just says all. So, like I said, we thought we were fully set for the whole thing. We did the little plot map and, you know, all the stuff, and we figured out where the septic would be and if we could do it. And we were to the point, really the only thing we needed to be finished was they have to test the water. And we would already had that done, but I had other things that were going on at the time. Life happens, but so I didn't get the thing done, so JJ couldn't test the water and get it all in. Otherwise, we would have been set for October 1st. We'd already talked to somebody to come and do the septic, and we were hoping that in a perfect world, you know, we'd drop everything in on the 1st. If it takes a week or two, by the first part of November, we could have septic in there and be all set. And apparently, like I said, now we're stuck. We don't know exactly what we're going to do. We're not trying to break the law, but we're trying to take care of family.
Mr. Neighbor, thank you for your thoughts and comments, and we understand you're in a difficult situation. Please give us a little grace and a little time to get this figured out.
You know, I don't think anything, any change isn't going to come like overnight or like, oh, we'll have it by Thursday of next week.
No, I mean, we can't. I mean,
in a perfect world, maybe
yeah.
you could do that, but I think then you probably even have more problems.
No, yeah, exactly. Nothing happens quickly, but we will make it a priority discussion right now. Obviously, there's some time-sensitive things going on, so we'll continue to talk about it. And when I say talk about it, it means like discuss it in seriousness, and figure out what we need to do on our end.
Yeah, if there's any, if you guys are any discussion, if I could come, I'd love to come. Maybe I can get my wife here. She works remotely part-time, so part-time. She works between here and Arizona. My in-law is poor health, so she spends most of the time down there. So
well, sometimes we have working meetings, which we do not make decisions at working meetings. They're strictly working meetings, but they are noticed, and a lot gets discussed. We won't make any decisions again unless it's in a public meeting. So just watch our agendas, and I'm sure Nicole, as we move forward, we'll probably reach out to you.
And I do appreciate you guys jumping on this pretty quick. It was because we just found out, I don't know, a week, 2 weeks ago that, here's the rinse. We thought everything was all good, and we're looking forward to October 1st, and then all of a sudden, and I realize it's not your fault. It's just how things happen sometimes. But I do appreciate you guys all getting together. I'm sure you had something better to do on a Friday afternoon than.
Sadly, no.
We're not that fun or cool. Well, we're fun. We're just not cool. We don't have that much going on. All right. Thank you.
Thank you.
Thank you very much. Go ahead. Coming up.
Hello. My name is Charles Freshman, spelled Freshman. I'm a licensed professional engineer, and I am a member of the planning board. I work under Nicole, and I want to thank you, Nicole, for putting up with me. I worked for DEQ for many, many years and did a lot of reviews and did a lot of these types of things, what we call rewrites. And what we would involve would be to basically is rewrite the COSA. And I've done ones where they involve building a ADU for mother-in-law, okay? And it does involve submittal of a lot of information to meet the DEQ requirements. And the time frame and the cost associated with that is, I think, a problem. My understanding, it's a problem for a lot of people to be able to hire a professional engineer to do a review of the sanitation and water supply issues and then submit the application to DEQ. And I think that's an issue. And one of my ideas I raised to Nicole at one point is if we could short circuit that review internally with the county and then submit just the revised COSA up to Helena, because it has to be signed by the director of DEQ and then embossed to make the process go a little quicker. So if we could do some of the review internally, I know it's a lot to ask for Nicole to do, but if we could do some of that internally, it would short circuit the time and the cost associated with that rewrite. And thank you for your time. And
Thank you.
Thank you so much.
Is there any other public comment? Else? Anything else from commissioners, from planning, from legal? Anyone?
Yeah, I would add, since they mentioned the sunset provisions, that specifically applies the sunset provisions specifically applies to the DEQ expedited review in SB 532, which is under section 1(7), and then the subsection B of 76(4)(130). So everything else is still going to be there after the end of the sunset provision. They're just what is going to sunset is the 15-day expedited DEQ review, because there were some concerns about the strain that could potentially cause DEQ. So they were going to do it, test it out for a few years. So that just wanted to add about it. Not everything is going away.
Right.
at
Thank
the
you.
end of the sunset.
Thank you.
Thank you. Appreciate it.
I had one more thought.
I could tell, because you're
Me too.
Because, I mean, as a lot of people said, I mean, right in the title where it says requiring counties to adopt certain regulations in relation to accessory dwelling units. So it lists all the different things that this is trying to do, and that's one of them. And with the confusion of what Section 5 could be, is it worth reaching out for an Attorney General opinion on this?
So if I may answer that, if you go to Section 1A, it states in jurisdictional areas where the Board of County Commissioners has established zoning regulations under this part, the regulations must allow a minimum of one accessory dwelling unit. So if you have zoning regulations under Title 76 Part 2, and you don't have any regulations concerning ADUs, this applies. If you do have regulations concerning ADUs and they're more restrictive than this, this applies. The more restrictive
does not.
regulations don't apply until you change your regulations. And that's why Mako said that even with subsection 5, this part of SB 532 still doesn't apply to us because we have not established zoning regulations under Title 76 Part 2. I would prefer it to be able to say that this still applies to us, because I think that makes this a lot easier.
Do you think?
And,
Yeah.
But because of how they worded subsection 1A is why it doesn't apply to us. Because, you know, the entire intent of this law is to address the housing issues in Montana. It's so that people can have, you know, an in-law suite on their property, whether that be for aging parents, grandparents, their, you know, the homeowners' kids who can't afford to buy a house or can't afford rent, whether it be here, Helena, especially Gallatin County, or just to, in order to allow people to have a little Airbnb house on their property that they can rent out to have some supplemental income. That is the entire intent of this law, and I think it's, I kind of wish they wouldn't have put it in the zoning section. I kind of wish they would have just said all counties must allow this, instead of just limiting it to counties that have established zoning regulations.
Yeah, you have to wonder what if they were thinking, if they were assuming that anyone who doesn't have zoning already has a process for ADUs. You have to wonder if that's what they were thinking, but it's the legislature, so.
Well, and I mean, kind of the common sense thought of it is if you don't have zoning, then there's nothing restricting you from having an ADU.
You would think.
Yeah.
Except your covenants.
Well,
So
There we go.
there you
but
go.
we're not
Circle.
focused on covenants anyways.
Right,
I mean,
right.
that's a whole different thing.
I think what we talked about today, and I want to say thank you again to everyone who
Yeah.
brought their comments and their thoughts to this, and I understand again that there's some timelines that are really difficult for people right now. I think what we talked about and finding a process to do this, I think we have a way forward, and we can work toward that. JJ, I appreciate your knowledge. Thank you. Same to Mary, all of you, Charles. We tend to defer to our county attorney. MACO, yes, says things, but MACO defers to our county attorneys. Just so that's clear for everybody, we just don't do what MACO suggests. And so I think our way forward, looking today, and please disagree with me, anybody that needs to, is going to be looking at how we make this process work. How we get a process. Let's just say we get a process in place that's going to work for everybody and that will meet the DEQ requirements, so we can expedite it. So we're looking at just changing those DEQ, the COSA, and so that can go in with the plat. That's what my takeaway is for moving forward. Does anybody else have thoughts on that? I feel like that's the direction we're headed at this time.
Can I
Please.
make a comment? First of all, Mr. Neighbor, this will be a priority for us. We understand it. We appreciate, again, your grace and you attending today. I have a couple of points, and I'll be really quick, because I do have plans.
Debbie's somebody.
First of all, please know I'm in favor of ADUs. My retirement plan, I don't know if my oldest son and his wife know that, but on their property, they have a studio that the previous person built because he was an artist. So that's my retirement plan as an ADU in Sun Valley, Idaho. So I'm all about it. Going over this, it brings up some other options, and Nicole and I think talked about it yesterday or the day before. Or not options, but issues. So just because I'm talking about issues, please know I want to find a solution for all of these. Addressing is made a little more difficult by it. Our regs say one, I don't know how it's worded, but one home per driveway. The driveways could be an issue. Right now, we don't have a lot of short-term rentals in this county, but more and more we will. Counties are dealing with that issue. And maybe this is clearer, and I just don't know it. Well, what size ADU? Does that mean a tiny home on wheels? Those kind of questions during this process, I think we need to look at too and be really clear moving forward. So since we're digging in this deep, let's just get it all done in one time, is my point.
Unfortunately, we live in rabbit hole world where everything turns into more questions, and a lot of legal considerations have to be made as well. Anyone else? Anybody else? Public comment or up here? Anyone? Okay. Oh, one more. Come on up.
So I guess I should have said too, we wouldn't have moved the trailer and started everything, but we talked to the planning commission and everybody, and we were told everything's good to go with it. Second dwelling could go. So
Totally understand.
And I really, I'm not trying to put blame on somebody, but it just, you know, and I don't have a solution for that either. I'm just saying we wouldn't have done it had we known this was going to be all this stuff. So,
and we appreciate you trying to do it doing it the correct way.
Yeah.
Thank you.
Well, like I said, we tried to talk to everybody. You know, got a jump start on it. And we thought it was all going to be good, and then
the sad. Well, I shouldn't say sad, but the challenging part is this is brand new legislation.
Right.
And as you can see, there's a different opinion about this legislation from every person in this room at some level. So, you know, it takes a minute to get that. And I think, Mr. Neighbor, I know you're frustrated, and we would, you know, like to, we will keep you posted. Like Commissioner Randolph said, this is a priority for us to get handled. And I think at this time, correct me if I'm wrong, having the trailer stored, so not hooked up, no one living in it, is not against anything that can be done. correct? It's just being stored on the property?
You're asking me, Madam Chair?
Yes,
Okay.
please, sorry.
Nope, I just want to clarify.
Keep forgetting
What-
to
no,
address
no,
you
no,
and
that's,
just look
it's
your way.
okay. I want to be sure that I'm responding appropriately. Yes, storing it is not a problem. And Mr. Neighbor, I want to be very clear. As the planner, not the planning commission, I didn't tell you everything was good to go. I said this new law was going to come into effect October 1st, that we would have an application process, that you asked if you could store the trailer. So there was, I want to be very clear, I didn't blatantly say, everything is good to go. Let me finish. But storing the trailer on the property, we have no county governance on that.
What?
So answering your question, Commission Chair.
Thank you.
I agree with the storing part, but you did say,
Mr. Neighbor, we'll have to, because we're not addressing specifically
Right,
your situation in this meeting,
Right.
let's take that offline and we
Okay.
can continue that discussion after, if
Okay.
you would, please. Thank you. Thank you again
Yep.
for your thoughts and thanks
Great,
for
thanks.
coming up. I know it's hard. JJ,
Sorry,
that's all right.
one quick comment. I think that with what Jesse said and Mary said, that, you know, for the preliminary plat approvals, I think there's at least a path forward on a bunch of these. Because if it says residential lots on the preliminary plat approval given by the county and then final plat filed, it's just a matter of changing the COSA. So for instance, Dry Gulch Acres Tract B could probably go forward because there is a letter that the county can give referring to the approval given through the county. And I just want to specify, I think that there is at least a good thing where you guys can proceed forward with some of these.
Thank you, JJ.
Thanks, Jerry. Jay.
Okay, anything else? Anyone? Thank you, everybody, for your time today. Thanks for coming in. We appreciate you taking time to be here and to comment. It's really important in this process. I will go ahead and adjourn the meeting. Holy fine, Jazz, you're popular now.
Holy moly.
Let's write this down. Megan, thank you.